Right. Well, I'd like to talk to you about Al Jaber and Mitchell, which is this Court of Appeal decision from the summer, which I think has attracted a little bit of attention since it was handed down. It relates to witness immunity and the extent to which it's available for people being examined in private examinations. It's actually a case in which I appeared on behalf of the unsuccessful respondents. But I'm going to try to avoid the usual case of losing barrister sour grapes. I'll leave it to you to judge whether or not I succeed. What I'd like to do in this talk is to look first at what the case decides, then look at whether it's right, and finally we'll ask whether it matters at all. But before we get there, I think we need to look at some of the background to it first. Now, the key individual behind this is Sheikh Mohammed bin Issa Al Jaber. He is, according to his Wikipedia webpage, a Saudi businessman, the founder, chairman, and CEO of the MBI Group. Now, the MBI Group owns a variety of different businesses, but among those businesses is JJW Resorts, which is the owner of a chain of luxury hotels. And some of those luxury hotels are still in operation and still owned by JJW Resorts. Now, the case actually involves a company called MBI International and Partners Incorporated, which is a BVI company. It went into liquidation in the BVI in October 2011. And since July 2019, its liquidators have been Greg Mitchell and Kenneth Chris of Chris Global. MBI had been the top holding company for MBI Group, and the Sheikh was a director of MBI and its sole shareholder. He was also said to be the controlling mind of various subsidiaries, regardless of their actual directorship. And it's one of the other individuals involved in this claim is the Sheikh's daughter, Mashael, who was also a director of MBI, as well as being a director of one of the other important companies, Holdings UK. So apart from MBI, the other two relevant companies were JJW Hotels and Resorts Holding Inc., which is a BVI company referred to in all the cases as Holding BVI. And this is a company which was originally owned by MBI. And the other important company was a company known as JJW Hotels and Resorts UK Holdings Limited, referred to in all the cases as Holdings UK. At one point, it was thought that this was the new owner of Holding BVI, but as we will see in a moment, that position is not quite so clear. Now, what happened? Well, a recognition order was made in June 2017, and the BVI proceedings were recognised by the English courts. And following on from that, a Section 236 examination was ordered in December 2017. And in the course of that 236 examination, there were two examinations by video link in April and November 2018. And in addition, the Sheikh was ordered to provide information by witness statement, and he did that by 3 separate witness statements over the period. And he had set out certain details of his dealings with MBI and its assets. And in particular, he had to deal with the issue of who owned the shares in Holding BVI. And in the course of his Section 236 examination and in those witness statements, he said that the Holding BVI shares had been transferred to Holdings UK, and that the transfer of these shares took place in 2017. Now, what then happened is that in May 2019, the liquidator of MBI commenced proceedings against the Sheikh, Mashael, and Holdings UK among others, asserting that through a series of transactions, both before the liquidation and after the liquidation, MBI had been divested of its assets, and that it had been divested of its assets at the instigation of the Sheikh. And these transactions were carried out in breach of the Sheikh's fiduciary duties and Mashael's fiduciary duties to MBI. And the claim sought equitable compensation of approximately $3.6 billion. Now, it's worth pointing out at this stage that I wasn't trial counsel. I became involved in slightly unusual circumstances, which I'll come to in a moment. But in the usual course of the application, the Sheikh made a witness statement in support of his defence to the claim. And that witness statement was consistent with the position set out in the Section 236 examination, in that it said that the shares in Holding BVI had been transferred to Holdings UK. Now, on the first day of the trial window, the Sheikh and the other respondents provided some new disclosure, which suggested that this position was incorrect. But there was no suggestion at that stage that the Sheikh was going to do anything to change his evidence or amend his witness statement or change his position in any way. What then happened is that shortly before 10:30 on the fourth day of trial, so after conclusion of the applicant's case and after the experts had given their evidence on BVI law and directors' duties under BVI law, the Sheikh changed his position by serving what was described as a list of corrections. And this list of corrections actually said that, contrary to what he'd said in the more than 2.5 years previously, in fact, holding BVI shares had always been retained by MBI. They'd not been transferred to Holdings UK at all. And that in fact what had happened in 2017 is that Holding BVI had transferred its assets and liabilities to Holdings UK. This prompted an application by the applicants, the liquidators of MBI, to amend their pleadings, which was made the next day and heard the day after that. So this all happened very quickly in the course of the trial. Now, the proposed amendments were as follows. First of all, there was an amendment pleaded to the duties owed by the Sheikh. It was pleaded that the Sheikh owed a duty to account to the liquidator for his stewardship of MBI and his assets prior to the liquidation. So for what he'd done with those assets before it entered liquidation. Secondly, it was pleaded that he continued to owe that duty after liquidation, or rather he owed that duty in relation to what he had done after liquidation, in relation to assets that remained under his control after liquidation, because obviously the Sheikh on the liquidator's case had not simply handed over control of MBI's assets as he ought to have done. And here it's important to note that for these purposes, there's no material difference between the duties owed by the director of an English company and the duties owed by the director of a BVI company. And in its decision, the Court of Appeal held that the fact that MBI is a BVI company is irrelevant to the outcome of the appeal. So although we're dealing with a BVI company, the issues involved can be read directly across to English liquidations. So far as the breaches are concerned, there were two breaches, relevant breaches of those duties that were pleaded. There's what I've called the positive breach, which is that by giving a false account in the course of his Section 236 examination, the Sheikh breached his duties to the liquidators. There was also pleaded what I've called the negative breach, which is that by failing to give correct information prior to trial, the Sheikh had also breached his duties to account. Now, just to explain how that happened, what I've called the first, the positive breach was pleaded first by Joe Curl, who was trial counsel. And then what happened is that the judge heard argument on the amendment application, determined issues of principle in relation to the lateness of the amendment and questions of reflective loss. And she found all of those issues in favour of the applicants. But there were some arguments made by the respondents that that the pleadings had not been pleaded with sufficient particularity and sufficiently tightly. And so she adjourned the balance of the application for Joe to go away and replead it. And I think it's important, in fairness to him, to bear in mind that he'd done this overnight. So he was working under extreme time pressure. So over the weekend, he repleaded into substantially the final form of the amendments, and provided the new amendments on Monday morning. And on Monday morning, the respondents raised for the first time this issue of witness immunity. And that issue of witness immunity was raised in relation to the positive, what I've called the positive breach. We'll look in more detail at what witness immunity involves in a moment, but just for the time being, it's that you can't be sued for what you say as a witness. So they said that in the course of everything the Sheikh said in the 236 examination was subject to witness immunity, and he couldn't be sued for the positive breach. So the result of that was that Joe went away, produced a further amendment which pleaded the negative breach, which wasn't caught by the witness immunity point. And then the amendment application was due to take place, I think, the Thursday or Friday of the trial. And the trial by this stage had to be adjourned in any event because it was only due to last till the Friday. Unfortunately for Joe, before the adjourned application could be heard, he became unwell, so I had to step in. And so that's where my involvement comes in. So that's where we are. I think the important thing, and as you can hopefully see, is that the positive breach and the negative breach are really just two ways of describing the same thing. So a director breaches his duty both by providing information which is false and by failing to provide information which is true. And it doesn't really matter which way you frame it, because you've got the same breach and the same loss. Now, what is the loss? Well, in this case, the loss as pleaded was that MBI lost the opportunity to obtain value for its shares in holdings, essentially by not realizing that it owned those shares. The liquidators were now unable to obtain any value for them because obviously without the assets and liabilities, the shares themselves are useless, and the liquidators say they now can't get back into the position that they would have been in had they known in 2017 what the position was. And the other aspect of the loss is that MBI's cost of the litigation itself increased because it pursued Holdings UK for a claim which was always untenable on the Sheikh's new evidence, because Holdings UK never became the holder of holding BVI shares. Now, let's pause for a moment to look at witness immunity. Witness immunity provides immunity for words spoken when acting as a witness in proceedings. And it's extended, it's not just what you say in the witness box, it's also what you say in a witness statement. but essentially it is directed at what a witness says in trial. It prevents a cause of action from arising out of those words. But it doesn't prevent the words from being used in evidence. And this is an important distinction to draw. It means that a claim which relies on the words themselves as giving rise to the claim, as giving rise to the cause of action, is barred. So an action for defamation, for instance. Relevant here is an action for deceit or an action for negligence. It doesn't mean that you can't then use those words as evidence of a claim if the claim arises out of other events, such as a breach of a freestanding duty, which is not breached solely by the use of those words. And it's worth pointing out that a similar immunity also exists for other participants in the court process. So judges, parties. It used to apply to barristers, but that's been removed, at least as against our own clients. And expert witnesses are now in the same position. So expert witnesses used to be immune from suit for anything they said in the course of a trial. But now if an expert underperforms at trial, then he can be sued for negligence or anything else for what he says actually in the witness box. Now, it's also important to look at the policy behind witness immunity. And there are 4 policy reasons which have been identified for witness immunity in the authorities. The first is to prevent witnesses from being harassed or vexed as a result of the evidence that they give. The second is to encourage honest witnesses to assist justice. The third is to secure that witnesses speak freely. And the fourth is to prevent a multiplicity of actions. Now, it was accepted by the judge at first instance that these policy reasons aren't engaged in a Section 236 examination. And it's reasonably clear why that's the case. So far as the first and the third are concerned, a Section 236 examination is held in private. So there's little risk of harassment or vexation because third parties can't find out what the witness has said or what the examinee has said. And so because of that, the examinee shouldn't feel constrained from speaking freely. So that's 1 and 3 gone. As far as the second one, well, in the case of directors at least, and here we are dealing with a director, they're under a pre-existing duty to assist the liquidator. That's in English law, Section 235. So there's no need to encourage them to assist justice. They have to. They don't have a choice. And finally, as far as the fourth one is concerned, preventing a multiplicity of actions, well, that has no relevance to Section 236 because no claim is being tried there. The court reaches no decision in the Section 236 examination. There's no risk of collateral attack on a decision of the court by suing a witness, which is what all the old cases relating to witness immunity are about. So again, that simply has no application to a Section 236 examination. And this analysis is one of the reasons why the court at first instance decided that Section 236 examinees were not entitled to immunity. Well, what about the Court of Appeal? Well, the Court of Appeal decided that actually Section 236 examinees are entitled to immunity. And the result of this is that the positive breaches that I referred to earlier could not be relied on by the respondents, who are the applicants to the claim. Now, it's important to note that the negative breaches could still be relied on, and that's important for reasons we'll come to later. But the result of this was that some, but not all, of the proposed amendments were disallowed. But it's fair to say that we managed to retain the majority of the amendments which had been allowed by the judge. So the judge had allowed all the amendments which we had put forward, and the Court of Appeal permitted the majority of those to be retained. Some remain to be argued over before the judge, but that's a different issue. Now, what was the Court of Appeal's reasoning? Well, the Court of Appeal's reasoning follows 4 stages. The first stage is to say that a Section 236 examination must be seen in the context of the compulsory winding up proceedings which they facilitate. And of course, here it's important to bear in mind that the Court of Appeal was dealing with a BVI liquidation. A BVI liquidation is this one in particular, in any event, was a court liquidation. It was analogous to our compulsory liquidations. It creates a single set of court proceedings whereby the court winds up the company. And so the next step was to identify the fact that in a compulsory liquidation, the compulsory liquidator is an officer of the court acting for the purposes of the court winding up the company in those proceedings. The next stage of the Court of Appeal's reasoning was to assert that the liquidator enjoys immunity in respect of statements which he or she makes in a Section 236 examination. And then the final stage of their reasoning was to say that it is unfair, or I think the actual word used was curious, but if you ask me, the tenor of the judgment is that it was unfair. Unfair if the examinee does not also have immunity, because everybody else in that room does, apart probably from me. Well, is it right? So first of all, fairness, this point that I've just identified. As I say, the Court of Appeal doesn't actually say it's unfair. It says that it's curious, that only the examinee is exposed to risk. But that concern appears to be one of fairness. To my mind, that reasoning is suspect. It's not clear, for a start, that any liquidator is immune in respect of things said during a Section 236 examination. Now, we're all aware of the provisions of Section 212 and how they can apply to liquidators. Unfortunately, the way in which this point was raised in the Court of Appeal didn't allow the Court of Appeal to consider it. The fairness submission was a throwaway point raised in the appellant's reply for the first time. So no one even looked at the way in which Section 212 might interplay with any liquidator's right to immunity out of a Section 236 exam, what they say in a Section 236 examination. And it seems to me that it is suspect at the very least to say that a liquidator is immune from action in relation to what he says or does in the context of a Section 236 examination. If a liquidator, for instance, declines to ask an obvious question and does so because it simply goes missing, it's not because they think, well, I don't want to alert the examinee to this line of inquiry, but just because they forget to ask. It seems unlikely to me that a liquidator could rely on any kind of immunity just by reason of the court process and Section 236. But that is the reasoning of the Court of Appeal. Now, even if the liquidator is immune, it's not clear why fairness or any other consideration demands that the examinee themselves should be immune. The rationale for liquidator's immunity, if it exists, would be to prevent them from being harassed or vexed for doing their duty as officer of the court by asking questions or causing their representatives, in reality, to ask questions. It's perfectly understandable why liquidators might be given that kind of immunity, although, as I say, immunity from a claim in negligence seems to me a very different issue. Now, on the other hand, immunity for examinees involves giving them an immunity from a breach of their duties to the liquidator and to the court. It's a very different matter. It doesn't involve an immunity from the risk of harassment. And it's not clear, to me at least, that it is either unfair or even curious if that immunity doesn't exist. Now, the third issue, which I think I would take with the Court of Appeal's reasoning, is the difference between a compulsory liquidation and a CVL. Now, key to the Court of Appeal's reasoning, as I've mentioned, was the fact that compulsory winding up is a court proceeding, and the liquidator is an officer of the court in those proceedings, and hence the liquidator's immunity. But what about a CVL liquidator? Well, neither of those two assertions made by the Court of Appeal holds true for a CVL. It's not a court proceeding, and the liquidator is not an officer of the court. And so, for instance, the rule in Ex parte James can't be invoked against a CVL liquidator. Now, if that is the case, how should a Section 236 examination brought on the application of a CVL liquidator be analysed? Could the CVL liquidators be left out in the cold by the decision? Are they liable? Are they not immune in a way that a compulsory liquidator is immune? Equally, is an examinee in the context of a Section 236 brought by a CVL liquidator not immune because the CVL liquidator themselves are not immune? It's not clear, but if the answer to those questions is that CVL is treated differently, it is very far from clear what possible reason there can be for that. If it is just an artifact of the difference in procedure between a compulsory liquidation and a voluntary liquidation, then that seems to be an extremely unfortunate result. And then turning to the policy reasons used by the Court of Appeal to justify their decision. The first was the risk of defensive answers in a Section 236. It was said that if a Section 236 examinee knew that they were potentially liable for a claim in deceit or negligence arising out of what they actually said in the course of their examination, then they might answer defensively, and the liquidator wouldn't get as full and honest a response from a Section 236 as they would otherwise get. Well, I think the kindest thing that I can say about that is that the judges clearly haven't sat in a Section 236 examination for a while. You always get defensive answers. You always get defensive answers because if you've got to the stage of a Section 236 examination, you're asking questions of someone who doesn't want to answer your questions. And that's why you've had to go to court. You get defensive answers, not because they are aware of the risk that they will be sued for those answers, but because they're aware of the risk that those answers will give away an underlying cause of action. And so, in my view, that first policy reason is completely unrealistic. The second policy reason is the risk to Section 235 interviews. Now, one of the arguments I made which the judge below agreed with, but the Court of Appeal didn't, was that if potential examinees become aware that they will be able to enjoy immunity from suit in relation to their answers in a Section 236 examination, then they will be less likely to agree to a Section 235 interview in which they may not enjoy that immunity from suit. Now, the Court of Appeal thought that was hypothetical. I have to say I disagree. I don't think it's hypothetical at all, particularly given that the current practice of the ICC judges is that they are quite reluctant to make cost awards on Section 236 examinations, certainly on the applications themselves. And I think that the availability of immunity will have to factor into the advice that is given to people facing requests for information, whether it's voluntary disclosure or formal Section 235 interview or otherwise. I think it will have to factor into that advice. Whether it will tip the scales in every case, I think that's a different issue. But I think the risk to them is far from hypothetical. Now, finally, does this case matter at all? Well, you'll be pleased to know that I haven't made you sit through half an hour of discussion about a case which I think is completely irrelevant. But in some ways, it doesn't matter. I've had several conversations since the judgment came out in which people have commiserated or complained about the result and said that they think it's terrible and it's going to cause them all sorts of problems. And I've generally asked them how many times they have brought a claim which they now wouldn't be able to bring. And nobody has ever said that they have ever even thought of bringing a claim like this. I've never seen a claim like this. All I can do is commend Joe and the rest of the legal team on the MBI case for thinking of it, because it is not an obvious claim to make. Almost always what you're dealing with in liquidation claims are claims arising out of the actions of the directors prior to liquidation, and not the actions of the directors in failing to provide information. Failing to provide information to the liquidators, that is. And so I think the category of claim in relation to which the main thrust of this decision applies is a very small category indeed. The second point in relation to that is that the negative breach is still actionable. So in fact, even though you can't bring a claim arising out of the words actually spoken in Section 236, you can bring a claim arising out of the failure to provide correct information, as of course the MBI applicants are doing. And I think, in fact, this is the most important aspect of this case. Now, before the judge at first instance, it was strongly argued on behalf of the respondents, the Al-Jaber parties, that a breach of a duty to account cannot give rise to any remedy in damages or compensation. And the judge at first instance decided that it was arguable that it did give rise to a remedy and left it for determination at trial. It is a key part of the Court of Appeal's reasoning that the breach of duty to account does give rise to a remedy in damages. That is why the Court of Appeal held that there's no unfairness in granting immunity to the examinee. So, in fact, as far as the MBI liquidators are concerned, the overall outcome of this this decision is actually quite positive. The positive breach was one which didn't matter because the negative breach was pleaded, and the issue of principle as to the breach sounding in damages has been answered in the affirmative by the Court of Appeal. And going forwards, I think if anything comes out of this case, that is what is going to be most useful and of greater importance. But of course, it is still, there are still certain circumstances in which that negative breach won't exist. For instance, often you have Section 236 examinations against accountants who aren't officers, who aren't auditors, and in those circumstances, there won't be a pre-existing duty to provide information. So, so if they lie in their 236 examination, it will be hard to bring an action against them. Other potential effects, well, I think claims for false provision of information may become more common as a way to reclaim the costs of litigation, or in another context, if information is provided after the expiry of limitation periods, then you can bring a claim for failure to provide information within the limitation period, so the claim could be brought forward. Apart from that, well, as I've already highlighted, I think office holders may well find that Section 235 becomes less useful. And I think it will be interesting to see if, it will be interesting to see if this becomes a position, a case where CVL and compulsory winding up start to move further apart from each other, because I think the overall trajectory so far has been them moving closer together. So that may be the other effect of this. But apart from that, I think, well, those I think are the are where we've got to. So sorry about this. I just need to get back to sharing my screen with you. Thank you. Now, there. Okay, so that's where I think we are. Are there any questions?